Some good news. So you can check out that on the website, tonyperkins.com. We'll have a link there to their portal. All right, very quickly, yesterday, as Jody was filling in for me, I was down at the Fifth Circuit Court of Appeals in New Orleans. They heard the oral arguments over state laws out of Texas and Louisiana pertaining to the display of the Ten Commandments in public school classrooms. Louisiana was the first state to pass such a law back in 2024. Now, what was interesting as I sit there in the courtroom listening is that the opponents of this, the Freedom from Religion Foundation, ACLU, their whole argument was saying that this is religious coercion, that children were being forced to, coerced into looking at these Ten Commandments, which was a violation of the Establishment Clause. Well, it just so happened that the Family Research Council filed a brief in this case, and it was focused on the issue of coercion. In fact, the Solicitor General, who argued on behalf of Louisiana's law, brought up our brief in his oral presentation and referred the justices to that. Well, joining me now to discuss this is the lawyer who wrote our brief, who has been working with the Family Research Council on a number of briefs, Christopher Mills. He previously served as a law clerk at the Supreme Court for Justice Clarence Thomas. He is the founder of Spero Law LLC, and he joins us now. Chris, welcome back to Washington Watch. Thanks so much for joining us.
Thanks for having me.
So your brief got a shout out yesterday in the court. I don't know if you saw that. But before we get into, we got about 4 minutes here, so we got to move quickly. But before we get into the heart of your brief, the brief that you put together for us dealing with this issue of coercion, why are these briefs that are filed important to the court?
Yeah, so these briefs are important because, the parties, Louisiana, Texas, the challengers, have a limited amount of words that they can present to the court. And in a case like this, there's a lot of issues. This case involves issues about standing, whether someone has standing just because he might see something on the wall, whether the cases are ripe when these displays haven't actually been used yet, and then all of these deep historical questions about what was the history of the Establishment Clause of the founding, what types of issues were going on in schools then, and so there's all these subsidiary important issues that the parties just don't have room for, and that's where briefs like ours come in.
So the opponents of this basically made their whole case surrounding this issue of religious coercion. That it was, the Establishment Clause prohibits religious coercion. But that means, and the justices, pointed this out, this means that you're forced to engage in some type of religious exercise at risk of penalty or reward. But the argument was made that posting the Ten Commandments, a passive posting of the Ten Commandments on a classroom wall, is not a religious exercise or service. I mean, the students aren't being forced to recite it. They're not being forced to read it. It's just hanging there.
Yeah. So what the challengers are really trying to do is go back to a test that the Supreme Court has finally gotten rid of, the infamous Lemon test, under which any government endorsement of religion could implicate the Establishment Clause. In the Coach Kennedy case, the Supreme Court said, no, that's not the test anymore. The question is whether there's an actual establishment of religion. And an establishment meant a formal coercion by force of law or threat of penalty to participate in a religious exercise. And that means like real coercion, in other words. And that was the issue before the court yesterday. Are we going to go with what coercion actually meant in the context of an establishment of religion at the founding, or are we going to basically sneak in this old Lemon test by defining coercion so that it means a poster that many students may not even see as they walk by?
And that was a point that many of the conservative justices were making. This Lemon test is no longer there. The Kennedy case, Joe Kennedy, the football coach, that case erased this issue with Lemon. But the attorney for the ACLU, the Freedom from Religion Foundation, he claimed, and he said this in the court, that posting the Ten Commandments on a schoolroom wall turns that school into a church. That was his argument. And I was sitting there looking at the wall, and I saw one of these signs, a fire code occupancy sign. So I guess if a church has a fire code occupancy sign hanging on the wall, it's now a government auditorium. I mean, if you follow their logic.
Yeah, I mean, it's absurd. That logic would mean the Supreme Court of the United States is a church because the Ten Commandments are up there, displayed in one of the friezes showing different historical lawgivers. That's just not a plausible argument. What they need to show is both coercion, formal coercion, and also coercion to participate in what? In some sort of formal religious ceremony. And that's just neither aspect is found here. There's no coercion and there's no formal religious ceremony. It's the state displaying the Ten Commandments in the same historical context that Ten Commandments have been displayed in for a long, long time.
Well, again, I want to commend you, Chris. Great job on the brief, and appreciate you working with Family Research Council to bring these arguments to the forefront.
Of course, happy to help.